the separation of property between spouses during the marriage shall not take place except by judicial order. Such judicial separation of property may either be voluntary or for sufficient cause. 190a. Article 135. Any of the following shall be considered sufficient cause for judicial separation of property: that the spouse of the petitioner has been sentenced to a penalty which carries with it civil interdiction; that the spouse of the petitioner has been judicially declared an absentee; that loss of parental authority of the spouse of petitioner has been decreed by the court; that the spouse of the petitioner has abandoned the latter or failed to comply with his or her obligations to the family as provided for in Article 101; that the spouse granted the power of administration in the marriage settlements has abused that power, and that at the time of the petition, the spouses have been separated in fact for at least 1 year and reconciliation is highly improbable. In the cases provided for in Numbers 1, 2, and 3, the presentation of the final judgment against the guilty or absent spouse shall be enough basis for the grant of the decree of judicial separation of property. 191a. Chapter 6. Regime of separation of property. Art. 143. Should the future spouses agree in the marriage settlements that their property relations during marriage shall be governed by the regime of separation of property, the provisions of this chapter shall be suppletory. 212a. Art. 144. Separation of property may refer to present or future property or both. It may be total or partial. In the latter case, the property not agreed upon as separate shall pertain to the absolute community. 213a. Art. 145. Each spouse shall own, dispose of, possess, administer and enjoy his or her own separate estate, without need of the consent of the other. To each spouse shall belong all earnings from his or her profession, business, or industry and all fruits, natural, industrial or civil, due or received during the marriage from his or her separate property. 214a. Art. 146. Both spouses shall bear the family expenses in proportion to their income, or, in case of insufficiency or default thereof, to the current market value of their separate properties. The liabilities of the spouses to creditors for family expenses shall, however, be solidary.